was a bit of a barn burner of a hearing. It was fun.
Paul Orphanides of Judicial Watch enjoys fighting government entities in court. This time he's fighting to make the Los Angeles Police Department to follow state law.
The hearing was about whether or not two entities represented by the ACLU could be allowed to intervene in our lawsuit challenging the LAPD, the City of Los Angeles, is their new impound policy. The policy for impounding cars driven by unlicensed drivers.
We asked him to explain department policy, which is called Special Order 7.
Special Order 7 is the new policy, the new impounding policy that the LAPD has enforced. It's a new policy, came into effect, I think, in the spring of 2012, and what it tries to do is to diminish the impact of a California statute that gives officers the discretion to impound the vehicles that are driven by unlicensed drivers. So if someone is pulled over and they're found not to be a licensed driver, under California law, the officer has the discretion to impound the vehicle.
But this is not subject to the whim of local law enforcement, it's state law.
The law is very clear. If you drive without a license, your vehicle is subject to be impounded. That's a decision that the legislature has made is important. It thinks it's important to protect the people of California from, and anybody else like myself who happens to be visiting, from unlicensed drivers. And the ACLU and their clients think that's too harsh. So they're trying to support the city's efforts to undermine that public safety measure.
For some reason, the American Civil Liberties Union is most concerned about illegal aliens instead of American citizens.
There's a claim that unlawfully present aliens are not able to get driver's licenses, so they're affected by this statute more often than others. And the two organizations that are trying to intervene in lawsuits, many of their members or their members' family members are unlawfully present aliens, and they're impacted by this new policy. They are benefited by this new policy that tries to minimize the impact of that California law.
Judicial Watch isn't involved in this case to argue for or against licenses for illegal aliens. They're taking this to court on the basis of constitutional law.
Our claim is basically that the city didn't have the legal authority under California law to enact this policy. There's impounding is governed by statute, something passed by the General Assembly up in Sacramento. And generally, the vehicle laws, traffic laws are supposed to be uniform across the state. So the California Vehicle Code actually says no municipality or local government shall enact policies concerning traffic measures. And that just makes sense, because you want the traffic rules in LA to be the same as the traffic rules in Santa Monica, right? You don't want that sort of block-to-block change to make a difference. We've gone into court and we're saying this policy violates California law, violates the California Constitution, because the city didn't have authority to enact the policy. The ACLU and their clients are saying, yes, it did. It did have that authority, and in fact, these are necessary. This policy change is necessary to protect against racial profiling and to protect against LAPD violations of people's constitutional rights. So what they're trying to do is inject into our lawsuit not so much issues about revisiting driver's licenses, but inject history and practices of racial profiling and constitutional violations. That's not at all what our lawsuit's about, and that's one of the reasons why we were trying to object. We did object to these people's participation in our lawsuit.
So they're not concerned about non-minorities?
I don't know how they would answer that. The focus of their argument is the unlawfully present alien community.
The position of the ACLU is peculiar in that they are only concerned with the impounding of cars taken from illegal aliens. The ACLU has said that they are targeting the illegal alien community.
Not targeting, representing them. They're trying to protect their interests.
They've actually said that.
Yeah, it's in. You have the papers in front of you.
Okay, so this isn't. Their primary concern is not about impounding cars of people in general that are driving without licenses. It's
Right.
only a particular group of people.
That's right. They're trying to protect unlawfully present aliens who they say can't get driver's licenses. They need driver's licenses to drive to their jobs, to drive their kids to school, and they say this California law has a disparate impact on them. It affects them more than it affects other groups, and I'm not quite sure I understand that. I guess because it's difficult for them to get driver's licenses.
We asked Mr. Orphanides if the ACLU makes any mention in their briefs if they are intending to protect people who are American citizens, whose cars have been impounded, in addition to the illegal aliens they seek to represent.
No. Oh, not at all. This is all about, according to their moving papers, a disparate impact on unlawfully present aliens. So they've gone into court and they're trying to say that they should be allowed to defend the new policy along with the city. And in addition to that, if they win, they were saying that they would like to recover their attorney's fees from our client, a taxpayer and citizen resident of the city of Los Angeles.
Ah, so now we learn the focus of their intervention. They see an opportunity to enrich their organization at the end of the trial.
We brought this lawsuit against the city of Los Angeles. We did not name these organizations. These organizations are trying to become parties to the lawsuit. So they are voluntarily, they're going before the court and saying, Judge, please let us be defendants. Please let us be sued in this lawsuit. Now, as part of that, they also said to the judge, if we win, we want the opportunity to recover our attorney's fees from the plaintiffs. So that would mean that people we did not sue, who voluntarily seek to come into our lawsuit to defend the city, would also be seeking attorney's fees from us in the event that they win, or in the event that we do not prevail.
This becomes a serious First Amendment issue. Having the ACLU pile on to soak up some extraordinary legal fees would seriously restrain people from standing up to government seeking redress, as Mr. Orphanides points out.
That impacts our First Amendment rights, the First Amendment rights of our client as a taxpayer and as a U.S. citizen to petition his government for the redress of grievances, and also under California law, there's this taxpayer provision that I mentioned that California's decided we want to encourage taxpayers to come forward in order to bring lawsuits challenging allegedly unlawful expenditures by the government. So if you're trying to encourage lawsuits, if you're trying to protect someone's right to petition their government, one thing you don't want to do is to chill that by having the possibility that they might have to pay attorney's fees. It's a fairly basic fundamental First Amendment right, this concept of chilling someone's First Amendment rights. And you don't want to do anything that would prevent them from invoking their rights or acting on their rights. But the ACLU apparently needs a primer in what the First Amendment means, because they didn't seem to understand this, that we are bringing this lawsuit in the exercise of our First Amendment rights. We have a right to petition the government. The government or the city would not have the ability to recover fees from us if we do not prevail. And yet they're seeking this extra benefit, this opportunity for fees. And what we said was that would have a chilling effect on our First Amendment rights.
And apparently the judge agreed, and in a surprising response, he reversed himself.
After about, I don't know, half an hour of back and forth, it was quite a barn burner of an argument, the judge actually changed his mind. He originally was going to allow the ACLU and their clients to intervene without any sort of restriction on their right to seek fees. At the end, he changed his mind, and he said, "You're right, I agree with the plaintiffs." And he used the phrase New York Minute. He said, you know, if I'm the plaintiff and I have brought this lawsuit and I now realize that I have, there's a potential that I could have to pay hundreds of thousands of dollars in attorney's fees to the ACLU or to anybody for having brought this lawsuit, I'd be out of that lawsuit in a New York Minute. That's what he said. I'd be out in a New York Minute. So he changed his position. He allowed them to intervene, which we were a little bit disappointed with, but he did at least recognize that there are some important First Amendment rights here that needed to be protected, and he said that the ACLU and their clients couldn't seek fees from us.
The ACLU prides itself on its defense of the First Amendment.
They used to.
Mr. Orphanides thinks his chances of defeating the ACLU and forcing the city of Los Angeles to obey state law are very good.
We've got very good, strong arguments. I think the California law is very clear that municipalities and local authorities are not supposed to enact their own regulations governing traffic issues. And I think that's exactly what the city has done. There's a lot of pressure, I think, to come to a different outcome, as there often seems to be in California. Laws are passed and people in governments don't seem to like those laws, so they come up with ways around them.
But we are supposed to be a nation under the rule of law, where we are all on a level playing field, whether citizen, police officer, or government official. We asked him if he thought Special Order 7 undermined the rule of law.
Oh, sure. I mean, I see this as a huge rule of law issue. And I mean, it's part of the sort of the corrosive effect of the whole illegal immigration debate and, the failure or the lack of an emphasis on rule of law there. But I think you see it in other contexts as well, even, the medicinal marijuana laws and how California's been struggling to deal with that whole debacle. I mean, I'll call it a debacle because it just doesn't make any sense. But what it is just a gradual erosion of the rule of law in general. And rather than changing the laws that are on the books through the political process, people go to court to try to undermine laws. You have municipalities and counties that try to cut corners and appeal to constituents by, softening the effect of the law. I mean, all of it's undermining the rule of law.
Our political process has been designed for maximum flexibility. If people don't like the law, we the people need to lean on our elected representatives to change the law rather than manipulating the law to benefit illegal aliens as a special class of people to the detriment of legitimate citizens.
And hopefully we had a little victory today where we won a victory for the right to sue your government to try to fix this, without having to feel like you're going to be financially ruined down the road if you don't prevail.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1. State law encourages citizens to file lawsuits against unfair government policies. In this case, the ACLU was asking to intervene so that citizens would be forced to pay their legal fees. Do you think that this would deter citizens from challenging unfair laws? Yes or no? Number 2. Do you think we need laws that protect special classes of people rather than equal protection for all? Yes or no? And number 3. The ACLU has always been an advocate for the First Amendment and free speech. Do you think their actions here will diminish their credibility? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you.